Okay, I'd like to call this August 28th meeting of the Multidisciplinary Committee of the Veterinary Medical Board to order. May we start with roll call, please?
Dr. Pollard.
Here.
Dr. Drusis.
Present.
Dr. Lazarchuk.
Here.
Dr. Warner.
Present.
Ms. Pawlowski.
Here.
Ms. Schufelt. Here. Mr. Ekman.
Here.
Ms. Laredo. Absent. Dr. Sullivan.
Here.
All right, looks like we have quorum. Agenda item number 2, committee chair's remarks. I'd only like to say that this is a little unusual in that we've had something of a wholesale turnover in MDC committee members. So I just want to welcome Stuart and Meg and Kevin and Leah, and thank you all very much for signing up for your tour of duty. And I want to have the audience introduce themselves and their affiliation, if you would, please.
Lynn Moon, California Registered Veterinary Technicians Association. Valerie Countrymaker, California Veterinary Medical Association.
Grant Miller, California Veterinary Medical Association.
Cindy Savory, RVT, Sacramento Valley Veterinary Technician Association. Joe Waterhouse, Veterinary Medical Board.
Thank you all. Agenda item number 3, review and approval of May 22nd committee member meetings. Does anybody on the committee have any additions, subtractions, corrections? Any comments or corrections from the audience on the minutes? I have only one on page 3 of 4, the first full paragraph. The last sentence says, "A discussion continued amongst the board and members of the public." The board should be the committee.
I would like to just make a general comment that these were very easy to follow, the way that these look, just the blue and the highlighting of them. I just wanted to make a general statement. They were very nice.
Yeah, I would agree.
And also they're in blue because they're hyperlinks. So if you were looking at the electronic version on the website, you can go right to the discussion on the webcast.
Yes. I did notice that. It was very nice. Thank you.
Okay, with that then, we need a motion to accept the minutes, please.
And the motion should be accept with revisions.
With revisions.
Yeah. So I'm going to assume that this needs to come from somebody who was there, and so I'm going to move with revisions.
Second, anybody?
Second.
If you aren't there, you can't second it.
That's correct.
Right, we have Dr. Sullivan seconding.
Okay, let's call the roll, please. Accept the minutes.
Dr. Pollard.
Aye.
Dr. Drusis.
Abstain.
Dr. Lazarchuk.
Aye.
Dr. Warner.
Aye.
Ms. Pawlowski.
Yes, aye.
Ms. Schufelt.
Abstain.
Mr. Ekman.
Aye.
Ms. Laredo is absent. Dr. Sullivan.
Yes.
Okay. Any discussion? Minutes? Okay. Agenda item number 4, election of the Multidisciplinary Advisory Committee Vice Chair. We need a nomination, please.
I'd like to nominate Christy Pawlowski.
I don't believe nominations need to be seconded, do they?
They don't need to be seconded, but the person nominated needs to accept the nomination.
I will accept the nomination.
Any other nominations?
Thank you.
So let's call for the vote, please.
Dr. Pollard.
Aye.
Dr. Drusis.
Aye.
Dr. Lazarchuk.
Aye.
Dr. Warner?
Aye.
Ms. Pulaski?
Yes.
Ms. Shufelt?
Yes.
Mr. Ekman?
Yes.
Ms. Laredo is absent. Dr. Sullivan?
Yes.
All right. Welcome, Christy Pulowski, Vice Chair of the MDC.
Thank you.
All right, agenda item number 5 is the update from the Complaint Process Audit Subcommittee with potential recommendations to the full board. I'd just like to make an opening remark that this is a continuation, as we all know, of a almost standing subcommittee the board has tasked the MDC 3 years ago, where the 2-member subcommittee has gone up to the VMB and reviewed closed disciplinary cases. And this time, Dr. Bill Grant, former member on the committee, having termed off, has been replaced by Dr. Kevin Lazarchev. And we met a couple of weeks ago at the board to review cases that are listed here, a highlight of them in the packet. And I'd like to probably first just defer to Kevin to see if you have any opening comments you'd like to make, and then we can discuss some of the cases or questions about them in any detail necessary.
I don't have any comments. It was an interesting review of these cases. We were particularly looking at from the point of
Can you put your mic on? I'm sorry.
Oh, there we go. We were looking at these cases from the point of the expert witness testimony, whether it was to the standard of care or a higher standard of care, and some of their statements that they made, whether it would lead to things being misinterpreted. It was interesting. The notes here are basically what we found.
This subcommittee has been something of an evolution in both obviously the number of cases continue to increase. I think we've probably read approaching 100 cases in 3 years. Probably met about 8 times. I learned something new each time. As I understand it, it was tasked to the MDC back in 2015 just with the global goal of improving the process, and specifically with regard to the expert witness writing and their reports to the DAG. And this particular collection of cases, I would just like to walk through the packet here briefly and then ask for any questions for clarification, because we just put a kind of a highlight of each of the cases. So there were 4 cases that we read that took the majority of the time. And then at the bottom where it lists extra credit, those were cases that we may not have gotten to. As it turned out, we did. And I would just like to point out, actually, at this moment, case number 5, where it says parole violation, that should be probation violation. It does have that tenor, though, when you read these cases, however. So I'd like to focus on several statements. Statements, now I'm referring to things that were literally read in the expert witness report and then ended up in the hearing in front of an administrative law judge. And I don't know how much detail we want to go into, because most of us, but new members being present, not all of us are necessarily conversant with the process. So just to give a description from the MDC subcommittee's perspective, these are 2 veterinarians that are reading cases of complaints that had been submitted to the board. The timing in this case, these were all recent, so I'll say roughly a year and a half at most earlier. And this was a complaint that public member makes, it ends up at the VMB. In-house, the VMB has 3 medical consultants, one of whom reviews all of the cases that are, all of the complaints that come across the board. Many of them have no further action. The subcommittee doesn't have anything to do with any of those that don't end up in this room on that day. And by definition, those cases went to hearing. They had an expert witness or more reports, and either resulted in a stipulated settlement, an agreement between parties that this is what we are going to agree upon with regard to settlement of the case, probation, fines, etc., or a hearing. The expert witness report is written by a veterinarian. Periodically, as we all know, on the front page of the VMB website, there's a solicitation for expert witnesses, people to come and write either subject matter or general expert reports. I don't know what the demand is. I can't imagine they're standing up, lined up outside the door, waiting to apply. But at the last enforcement report by Candace Rainey, the enforcement manager at the time, she indicated there were 15 expert witnesses currently working for the board. This is the first time in our review that all, in this case, 6 cases were written by current experts who are presently writing reports, some of whom have years of experience, some of whom are relatively new. Having gone to a few of the expert witness training sessions, Dr. Grant and I attended one in San Diego in November of 2016, another one in April of 2017, that was in Sacramento. There was one that I missed during my MDC tenure in May of 2000. Chef, not having gone through this exercise before, we would not simultaneously be reading the same case, but he'd read case number 1 while I'm reading 2, and then he's reading 1 and I'm reading 3. And at a certain point, we would have the experience that we're reading the case and then looking up and almost asking, like, did you see that comet go by? Did you read what I just read? Did that really make sense? And so, as a committee member, as a subcommittee member of this, and having had some experience with the current experts, some of whom have written these statements, I was concerned, I think we both can say that we were concerned about comments like this ending up in an expert witness report, ending up in a hearing before an administrative law judge. Because these are comments that are not based on the facts of the medical record. You can't say things like the callous and cavalier attitude of the staff and doctor exhibit. That just is not going to be very revealing or helpful on anybody's part. Case number 2, if a more thorough exam had been performed, perhaps the OVH incision would have been noted, or not. I think I would just add to that kind of series of concerns that it's difficult to see the whole process, which obviously an expert witness doesn't. An expert witness is a veterinarian, as I recall from the requirements, with valid license and good standing with the state of California and 5 years of experience. A rather low bar if you think about it in the grand scheme of experience and what we do and what we know and how we are expected to pass judgment on a fellow professional. But the reality is an expert witness testimony is necessary in order to pass a sanction on a veterinarian in a case. So they receive the complaint, they receive the medical record, they receive any details about investigation pertinent to the case. They don't receive accusations, which is what the legal people can fill in the details for me, but that's what the state is proposing against the veterinarian, referred to as the respondent, that something went wrong. Their expert witness report is intended to be the basis for which the respondent is going to face some sanction for action or inaction. Christy?
Well, in reading these comments, it actually suggests bias right from the start. It shows there's a bias on the EW's part, and that there should be no favor towards one side or another when reading this, is from my understanding from the training, is what I came away from that expert witness training saying you're not supposed to go in with any bias one way or another. And reading these, I said there's bias.
And you're referring to the comments in this report, not just the witness, expert witness training you attended?
No, correct. The expert witness training was very clear that you should not have bias. You should go into this completely free. You're not supposed to have a view one way or another. It's kind of like being a jury member, a juror. You should not have any type of opinion one way or another. And in reading these comments, it seems to me they've formed an opinion before they went in.
I would only add that the juror part is actually more analogous to the administrative law judge. The expert witness really isn't a juror. In fact, isn't in a position to pass judgment. The second part of my concern with this is the other things that Dr. Lazarchev and I read that are part of these closed cases are the legal material, the accusation, the amended accusation, the decision. The decision is what the judge comes to and the parties sign off on at the end of the process. We got to read all of that. And when, in case number 5, the patient presented with signs conclusive of diabetes mellitus, that case had a lab report indicating the blood glucose was 466. For anybody that doesn't know, dogs have a normal range of about the same as humans, so 80 to 120 depending on the lab. So 466 is unequivocally high. But if you make a statement as an expert witness that a blood glucose of 466 without any other information is conclusive of diabetes, that's going to get shot down in a heartbeat. It's patently inaccurate. At best, it's suggestive. And it was very seminal in this particular case because it turned out not only did this particular patient have diabetes, it actually had it actually probably was diabetic ketoacidotic. But we don't know that because there was no urinalysis done. And the end of this case was not positive for the pet or the pet owner. And the lab work that was or wasn't done was part of the problem. So if you write something like this and it goes to the the Deputy Attorney General, who is the one who writes the accusation, this is a lawyer. This is not a veterinarian or a medical doctor. This is somebody who has to take it on face that this particular pet had diabetes or not. And so that made it into the accusation in this case. It didn't have a material meaning in the outcome of this case, but it could. And so what I would like to be the takeaway for this, or at least one of, is when the next expert witness training session happens, the substance of these reports gets presented. And segue, One of the questions that I had when we met a couple of weeks ago was to Candace Rainey, was do these MDC subcommittee meetings have to continue? Are we in a place in the process where two members from the MDC tasked by the VMB go up to Sacramento a couple of times a year, it's worked out to be, to spend a day reviewing cases, write a report, spend some time at the meeting and present it? And she was vociferously and unequivocally encouraging it to continue. So I would like to stop for a moment and ask everybody's thoughts about, based on what you've heard and what you've heard in the past too. I think this is an accumulation of 3 years of work thus far. Is this worthwhile? Is it necessary? And should the MDC be the ones doing it? Dr. Sullivan?
Absolutely. And I think your examples and Candace's comments go hand in hand. I have looked at closed cases before. I was told I couldn't do it anymore. And they're very informative. It's a great experience. But the importance of the subcommittee is to give continual feedback to the expert witnesses, and these are great examples of what we need to avoid. And the only way that we're going to improve the expert witnesses is by critiques. And this is the perfect committee to do it, and the expert training program is the perfect way to deliver it. And when done correctly, I think it's a great learning tool. So I would definitely encourage its continuance.
Other comments from the committee? Christy?
I agree with Dr. Sullivan. If it doesn't get back to the expert witnesses, then then we're doing this for nothing. So I think it needs to get back to the expert witnesses, but I think it needs to continue because I think that they are receptive and willing to learn, and I think that they will grow from this. And it's the only way to improve the program.
I agree. This needs to be an ongoing topic, an ongoing, I wouldn't say investigation, but an ongoing process that this committee needs to engage.
Any comments from the public?
Okay, my name is Bonnie Lutz. I know a lot of you. For those of you that I don't know, I'm a lawyer. My practice is limited to only defending veterinarians in administrative actions. I do an occasional lawsuit, but not very many. So I've done this for 19 years. So I've been through a lot of these processes, and I would highly encourage you to continue to review these cases because there are a lot of very unprofessional comments that are made in those expert reports. And the experts really need to be encouraged. Not to make those unprofessional comments because they're not evidence. It does end up being embarrassing, which I intend to do, for the expert when they make these unprofessional comments. The other thing that I'm finding out, too, that really disturbs me is that a lot of the older deputy attorney generals, they really pored over those expert reports, and when they wrote their accusations, they made sure that the regulations were correct, and they left out those stupid comments that were biased and unprofessional. The newer DAGs are really overworked, and I see more and more that the accusations are coming word for word from those expert reports, and some of them are just downright, so unprofessional that it's ridiculous. So I really encourage you to do that and to get this information to the people that are doing the training so that these experts understand that they're not supposed to be biased and they're supposed to be professional and they're not supposed to have knee-jerk reactions. I also would encourage you to try to get the expert witnesses to have training on the regulations and how to interpret them because they just make up their own stuff. as far as how they're interpreting the regulations. I can give you examples, but I don't want to take up a lot of your time. But they need to not only know about standard of care, but they need to know with the regulations, because again, the older deputy attorney generals that I have been working for years, they would look up the regulation, and if the expert said, you know, it's in violation of this regulation because they're supposed to do X, Y, Z, then that deputy attorney general would say, well, no, that's not really true. So in the accusation, it would not be there. But now the DAGs are just automatically putting whatever the experts say. Also, I found out something disturbing 2 months ago that I didn't even know, that sometimes these accusations are ghost-written. Now, I asked what that meant, and I didn't really get a good answer. I think what's happening is when that deputy attorney general is really busy, all that stuff is just going to maybe even a clerk or somebody in the attorney general's office, and somebody else is writing that accusation, and the person, the DAG's name that ends up on the accusation, didn't actually write it. So when I questioned this one DAG and I said, you know that, you know, whatever the case was, you know, this regulation doesn't mean that, she said, oh, I'll have to look at that accusation because it was ghost-written, meaning somebody else wrote it. So again, it's all those experts. They really need to be not biased and professional and know the regulations. And I would encourage you guys to keep doing this.
Other comments? Kevin?
I think it's really interesting. The whole time we were sitting there, we were thinking, we were looking at a lot of this from the standpoint of Bonnie Lutz would have a field day with this, and you're up there telling us to continue on.
Good point.
Can I add one thing? Can I add one thing? I just wanted to add to, I did recognize the comments that are made in some of these cases, and I think it's great to deliver the training, deliver this feedback during training, but I'd rather not wait for the training to deliver the feedback specific to the subject matter expert. So what we're doing now is once we get these reports, not only with our subject matter experts, but also DFI investigative reports that we get, if we have concerns, especially things that have outside opinions in the report, we will provide immediate feedback to that subject matter expert and then also use it for future training, because I'd rather fix the issue as soon as it happens and then use that for future examples.
Question along that line, if it's continually the same person, the same expert witness, I would like to make sure that we're handling that too, because I don't want it to be, we're lecturing a group of people and they're not the problem, bless you, they're not the problem, but it's one person, one individual. We need to make sure that we're addressing the one individual instead of addressing a group of people that aren't necessarily the problem.
Yeah, absolutely. And it's from my understanding that the specific feedback hasn't been provided to the experts. We've just stopped using them. So I would like to provide an outlet to provide that immediate feedback. And then if we continuously have problems, we just won't use the expert again.
I would just add one more thing, and I didn't explicitly include it in the subcommittee report, but I'm sure Dr. Lazarchuk will concur. Think about this on occasion and wonder what could be done to, improve the process. Candace, for example, Candace Rainey made mention at the May 23rd Veterinary Medical Board meeting in her enforcement report, the number of complaints are approaching 1,100 a year. 5 years ago, they were 600. The board asked her what her opinion was about why the increase was the increase seen across DCA and other boards. I don't know that I heard what she said. I'm paraphrasing, but as I understood her, she feels that the ability to file a complaint, the exposure of the VMB, perhaps the website availability, all those things are big factors, if not her main factors. Whatever the reason, and the number of complaints is, disturbing. Talk proportion and percentage, and I don't know what's normal. I don't know what they do in Texas or Nevada, and it really doesn't matter. where we are. But if there was one thing that I would like to see changed or improved that would make a huge difference from the Veterinary Medical Board's perspective, from the veterinarian's perspective, say nothing about the pet owner and the pet, 3 words: better medical records. We saw cases, again, in this review where, I have specific preferences, as I'm sure we all do, whether we know it or not, about what makes a good medical record. But there are rules about what should be included, and yet, at the same time, you can write too much. Rarely is that a problem. It's quite the contrary. It's usually the opposite case. And logically, you would think that sloppy, written, incomplete medical records all go together, but I've seen electronic medical records that are wholly deficient. Their only purpose was to kill a few trees. They really don't have substantive information that really is necessary. And just to give a shout out to Bonnie Lutz, and one other entity that I think has been, in my 20 almost years in California, really the only avenues of advancing improved medical records. Bonnie Lutz, and I don't know any other attorneys that have presented at continuing education meetings. I think I've probably heard her 6 times over the years present on medical records. The CVMA at the annual meeting, PACVET, has an inline program where they consult with the legal firm Wilkie and Fleury, and they put on a half-day program detailing issues of veterinary medicine, medical records, insurance, and employment things. And I remember attending one of those. I remember Dr. Waterhouse and Dr. Sullivan were in the same session a few years ago, and Dr. Sullivan made the seminal comment. He said, "This room should be standing room only," and clearly it wasn't. It's not exciting as Cushing's disease or whatever floats your boat, but it's really important stuff, and better medical records. I like to think if there was one simple basis for which you should template, if you will, write the record that would be available to the next person who's going to see the case and pick it up at that point, and not have to text you, call you, or worse, guess what you thought and where you were going. You don't even have to have it right. You don't even have to get the diagnosis spot on at that stage of the case. But if the person who follows you has an idea of what your thinking is and your thought process is reflected in the record, things are going to go better for everybody. Okay, that's my soapbox. Any other comments from the committee? I would like to continue. All right. So we're up to agenda item number 6, update from the public and private shelters and minimum standards, protocols for shelter medicine subcommittee. Dr. Sullivan.
Thank you. You made me a little nervous there when you were going to quote me. Some of my quotes aren't always that good. Okay, Jennifer is not able to be here today because she's starting her new position as professor in the Agricultural Science Department at Mount San Antonio College in Walnut, California. So congratulations to her. We both went back over the webcast for our last MDC meeting to kind of update ourselves on this issue, because when I looked at my notes, I couldn't figure out one of them. And I hope everybody else on the committee was able to go back and kind of look at them also, because it kind of put everything back together. So we got together and we kind of went through the same sequence that John and David did. So if it's okay with the chair, that's how we'll proceed. Okay? It is a little disorganized in our packet. We kind of jump back and forth. Hopefully that doesn't confuse too many people. I'm going to start on the second page where it says beginning of report. That first section we actually moved to the proposed new section 2030.6. Tara and I had some discussion on this. What we're going to try to do is to put this into regulation, and there may be some question by OAL as to whether we have the authority to do that. If they object, then what we'll do is pull it out of that preface area of 2030.6 and put it into statute. So we're going to try to do it through regulation. So we'll get to that in a minute. So the first section that I'd like to open for discussion is section 2035, duties of a supervising veterinarian. And the notes at the bottom in red are just notes that I put in there so I wouldn't forget. So this is existing regulation. Item B and E are new, and I'd like to just quickly make a change. I think in B, we should also put in permit holder. So the second line should say healthcare task to RVT, comma, erase or veterinary assistant, comma, or permit holder. I think that's the way it should read. So, and then that requires clinical skill and judgment that is beyond the training and demonstrated compensity of the RVT, veterinary assistant, or permit holder. I think it's pretty self-explanatory and would open up for discussion to see if there's any questions, concerns, or additions.
Committee?
Okay, so I realize that C is already there. However, to me, it is quite confusing in that the supervising veterinarian of an RVT, the supervising veterinarian of a permit holder?
Yes. So if you're telling a permit holder to give a controlled substance to a patient, that has to be under the supervision of a veterinarian. Correct?
Permit holder meaning the premise permit holder?
No.
The veterinary assistant, controlled
Okay, so
substance.
I think that needs to be thoroughly clarified.
Okay. Well, then we'll do that globally then.
Yes.
Okay.
That's exactly my point.
Okay.
I just want to point out that under regulation CCR section 2034, it provides animal health care task definitions, and subdivision K defines permit holder to mean a person who must be at least 18 years of age and is a holder of a VACSP issued pursuant to section 4836.2 of the code. And this is sitting, it's the section right before the one we're talking about, 2035. So I think that definition is sufficient to apply to the rest of, I think it's the article of where this section sits. Yeah, it's Article 4 practice. So permit holder would apply everywhere under that article. I think that's clear enough.
We define premises permit holder whenever we say permit. It's premises permit. It's not I don't think we use it as a permit holder. We don't say permit holder. We don't use it as a premises permit. We define it as premises permit.
My point is that the expectation is that we all have the collective knowledge to understand these things. And it is confusing to us. The average person, the average veterinarian, the average RVT, veterinary assistant who may read this, I don't believe is going to spend the time to try and figure out the nuances of all of these regulations to put everything in their proper perspective.
In the past, what we have done, and I see that Tara has changed that, I think that we have, on the initial definition, then in parentheses, put the acronym, and then use the acronym later. I don't know if that's acceptable. It may not be in the legalese arena.
So what are you suggesting? Instead of permit holder, say VACSP holder?
Yeah, or VASCP.
I think you would probably want to do a global change. That might be a section 100 change, just to keep it separate and apart and hit all of the references to permit holder. But probably going forward, as far as this package was concerned, you could go ahead and just switch out permit with VACSP to make it clear, and then separately clean it up everywhere else. But yeah, that would be probably helpful for anyone having to look at the regulations and not understanding in context what's before it. And most importantly, for the board's purposes, it's probably animal patient clients, in case they're having to look up the law. I think it would be clearer to the consumer.
Okay, so that will be direction to staff to be consistent in that fashion then. So I guess what I was kind of going with, is everybody comfortable with section B? Okay, so we've got the comment on C and as it relates to the permit holder.
Can I clarify real quick
Sure.
on B? So you added to, was it the second line of subdivision B, comma, permit holder, comma, or, for veterinarian, the RVT or veterinarian assistant?
Yes,
Did you also make that change on the last line?
yes.
Okay, great. Thank you.
Okay, then, so I think what we'll do is address item E and then go back and once we agree on it, maybe make a motion and for the whole section then. Is that all right? Okay. So item E, and you've also seen my comments below, and so I'm kind of going to defer to Alan as to why aren't we giving these animals rabies vaccinations as we do distemper and parvo vaccines when they come in?
A couple of reasons. If we step back in time to the bad old days of animal sheltering, when clearly 50% of the dogs were euthanized and did not have live outcomes, it's a waste of time, money, and effort to vaccinate them for something that in 3 days you're going to euthanize them. That was the perspective back then. And nowadays, that certainly has changed. A lot of the shelters have a live release rate that is a lot higher than it was 15, 20 years ago. But there is not a veterinarian who has performed a examination on the animal prior to it being impounded that would then qualify as an exam and rabies vaccination ability, whereas distemper and bordetella and all the core vaccines, it is generally accepted that they, in the shelter circumstances, don't require a veterinarian to have previously examined the animal. The other issue with rabies is that it is not effective legally for 30 days after the administration. So even if you gave it on day one or day zero of the impound, the animal is not legally considered immunized until 30 days thereafter. So it becomes confusing, if at the very least, as to whether it's been legally vaccinated, and it's just another step that staff needs to take that maybe is not necessary if the animal, certainly they're all in one way or another owned, but as they present to the shelter, they could have a current rabies vaccination, and the one that might be administered on impound is then redundant.
Well, that would be true with the other core vaccines, too.
However, the incidence of parvo and distemper are much higher than the incidence of rabies.
Yeah.
If we were in China, I wouldn't be saying different things.
What we're saying in the vaccine clinic section is that a veterinarian has, physically looks at the animal and in that cursory examination feels that the animal's healthy enough to receive a rabies vaccination. Can that be done on entry also? Let's say some written form of this on the record of the animal so that we can justify it in both cases? My concern is we're asking for a public or private rabies vaccination clinic that a veterinarian evaluate the health of the animal so it can receive a vaccine. Very cursory. I guess I don't see why that can't also be done in a shelter prior to the release of the animal so the vaccine can be given at the time of the release.
Well, certainly, prior to release, either through adoption or redemption, I certainly agree that is something that should be done. It would save everybody a lot of time and effort, especially the owners. My concern would be on impound and those animals that are not going to have a positive outcome, or those animals that are very difficult to handle, aggressive animals. It's a safety issue for staff if, in the long term, the rabies vaccination was not really even indicated, because it wasn't going to get redeemed by the owner, or was going to be euthanized because of its behavior.
So are those same animals receiving the core vaccine?
Sometimes they are, sometimes they're not. It depends on the staffing level and their expertise. We don't like to manhandle the dogs too much. So if there's owner information on an aggressive dog, we generally try our best, certainly, to protect them from the contagious diseases that might befall them in an animal shelter, parvo and distemper, and kennel cough to a certain extent. But if there's no owner information and the animal is too dangerous for staff to safely handle, nobody touches it.
So maybe we can address this then by saying, if the animal is healthy enough to receive a core vaccine, then at some point in the stay of this animal in the shelter, it is healthy enough to receive the rabies vaccine. And have that in your protocol so that on getting the animal back to the owner or by adoption, that animal can receive the rabies vaccination with the understanding that by the veterinarian has authorized its vaccination because of the health of the animal receiving the core vaccine.
I agree. Generally speaking, now this is a time issue as well. Certainly if an animal is impounded into the shelter at 5 o'clock minutes before closing on one day, and at 9 or 10 o'clock the next morning, the owner's there to pick it up. Obviously, a veterinarian probably has not had the time to look at it. If we're talking about the 72-hour hold for stray dogs that's currently mandated, or has referred back to those days when it was 72 hours, generally, at least in our shelters, a veterinarian has had the time to walk through and assess the general health of virtually every animal that's in the shelter on numerous occasions. And so then that would be the case. Our particular problem, and the example I use all the time, is Blythe, in the middle of Arizona. There is no veterinarian out there that walks through the kennels on a even weekly basis. I rely on trained animal control staff out there. I would not have them vaccinating, but I could understand the circumstance, and I'll bring it up a little later, we were discussing earlier, that someone would interpret this then in a situation where they don't have a veterinarian, or they know that the vet's not coming out until Friday, and this is Monday, and they would go ahead and vaccinate it anyway, when no one has looked at it, essentially. So I think there's a fine line here.
So how are you suggesting we address this then? You think we need to go with this wording as it is right now? And because to me, it's not compatible with the vaccine clinic.
Well, it's not a vaccine clinic. This is, this discussion is about.
Yeah, but what I'm getting at is how can we say there's one standard in a shelter and a different standard in the public? A public vaccine clinic or a private rabies vaccine clinic?
Well, at a vaccine clinic, there has to be a veterinarian present.
Correct.
Has to be. I understand your logic and your concern about having two paths for the same result. However, vaccination clinics and animal shelters are not the same, and small animal practices are not the same as animal shelters. And we may have to carve out special considerations for animal shelters so that they may work more efficiently and provide greater public health.
Yeah, where I'm coming from the board is that, and I have no problem going with this as long as we have everything up front, but when we then turn around and cite a vaccine clinic for the veterinarian not being on the premises the entire time, I think we may have a problem with a good attorney holding that up when we are allowing it in a shelter. That's my concern.
I understand your concern, and I think you understand my situation. I don't know how anybody else would feel, but certainly in a shelter that has veterinary staff, the animal would be, under normal circumstances, looked at by the veterinarian once in the 72-hour time frame. But I don't know how we can incorporate that into regulation either. I mean, it's virtually impossible.
Then I will turn this discussion over to the rest of the committee to come up with a recommendation.
So, question, Dr. Sullivan, if the two options that I hear being discussed are rabies vaccinate on intake like we do with the core vaccines versus what is currently the norm, I don't know if norm is the right word, to vaccinate on relinquishment or recovery.
After a veterinarian has looked at the animal.
I think your example of Blythe is a perfect example. We have to address that. And I'm, that's why we need shelter staff, shelter veterinarians and RVTs here, because we need those examples of what we have to resolve.
And it's not just Blythe, it's a host of all other organizations
yes,
that do not have.
That's a great example, though, yes. Does our legal have any problem having this kind of a difference between two literally administrations of the same vaccine when we say in an animal shelter? Can we defend those two situations?
You can if there's a practice reason. It's not really a legal question if you're using one scenario for one situation and providing a different requirement somewhere else for the same vaccine. It's really about, because 2035 applies to everyone.
But
I don't understand, though, why you are incorporating subdivision E under 2035 if it speaks to shelters solely. Wouldn't that go under the shelter provision to maintain consistency, and everybody knows then where to put it or where to go for the animal shelter stuff? Because 2035.5, the title of it is Duties of the Supervising Vet, RVT, and VAs.
So you think it should go over there?
I think at the very least it needs to be over there.
Okay.
We can move it so that way they're all sitting under the right, or at least one section. Now, whether or not you think this committee, because you're the practitioners, if you think that administering rabies at step one is a bad idea for the health of the animal, and that's different than administering the core vaccinations at step one, it's a practice issue that you guys need to resolve. And I think if you move subdivision E to 2035.5, it starts to get more clear about where there's
The difference.
a disagreement, yeah.
Okay. I'm fine with moving it.
One general question I have about 2035.5 is that if we move this, does this apply to VACSP holders? So currently, 2035 talks about VACSP holders. We just talked about changing the title of it, but when I look over at 2035.5, I see RBTs and VAs.
Is there any reason the VASPC holders couldn't be added to 2035-5?
I have added it in my notes. It's not there, but I have a note to add it.
Well, that answers that question.
So I think to move this along, I would move that we approve the changes to 2035, CCR 2035, with moving item E to 2035.5 in its appropriate place. Now, I don't know what's proper. If you want input from the public before we make a motion, maybe that's the proper thing to do.
Any other questions from the committee? Any questions or comments from the public?
Ellen Moon from Carveta. We agree with moving Section E to 2035.5. Also, to answer your question earlier, Dr. Sullivan, the reason why a lot of times shelters don't do rabies at impound is because we're dealing with the unowned or uncared for population where distemper, parvo, bordetella, those can readily infect our patient population. So those are very important to do. Rabies, we're not worried about so much. Quickly infecting our patient population. It's not spread quite as easily as parvo or bordetella. The other thing I wanted to say was that rabies is such an important disease from a public health standpoint that we want to be sure that somebody who's trained and knowledgeable administers the vaccine. Somebody who is under the direction of a veterinarian who has the training and education to understand when it's appropriate and when it's not to give a vaccine, and who can call a veterinarian to say, hey, doc, this doesn't seem right. Is this okay for the health of this animal to give this vaccine at this time? So I think it's very important to keep the RVTs in the loop and at least have them supervising if we're going to allow veterinary assistants or permit holders to do rabies vaccines in the shelter.
Thank you.
May I say something about you asked about the legality, and I think fleshing out what the differences between the rabies vaccine and the core ones in the rulemaking package helps justify having a differentiation. So rabies is different than the core vaccines because it's less spread through the air to infect all of the other animals in the facility. It is mandated by the Health and Safety Code. I don't know. It's more about maintaining the human public health rather than animal patient health. Do you see what I'm getting at?
Okay.
Yeah, if we can just provide the differentiation in the initial statement of rulemaking, we'll get there. We'll be able to figure out why it's separate.
Okay.
Erica.
Good morning, Erica Hughes, California Animal Welfare Association. And just as history to why E became a topic of conversation, it was a request from the sheltering community because they want, particularly public animal control agencies, because they want to be able to license animals when they're redeemed by owners if they're not licensed, and they can't license them without the animal having been vaccinated against rabies. So from the sheltering perspective, it's a licensing and public health issue. It wasn't so much that it wasn't about differentiating between rabies and other sorts of vaccines. It was about getting animals licensed. And I think it's important to just remember that we're talking about allowing shelter staff to vaccinate under the supervision of a veterinarian. And so while it's great that many shelters have RVTs that are able to supervise veterinary assistance, that's certainly not the case for the vast majority of shelters throughout California. And so to make RVT supervision a prerequisite to the administration of a vaccine in this narrow circumstance would really render this exception unworkable for most shelters. So, thank you.
Okay. In addition to what I do defending veterinarians, I've also had a lot of contact with shelters. I've represented several large shelters. So I just have a couple of questions. While you're going through the process of revising 2035, can we get clarification on D, which I've been able to successfully argue both ways, but it would be nice to have clarification, where it says the supervising veterinarian shall have examined the animal patient prior to the delegation. So that seems pretty clear to me. But then the next sentence says the examination shall be conducted at such time as good veterinary medical practice requires. So, as I say, depending upon what side I'm on, I've been able to successfully argue that the examination has to happen before there's any delegation, and then I've also successfully argued that it can happen as good veterinary medicine dictates, where I have an expert that says, well, no, it didn't have to happen before it was done, it could happen shortly after it was done. So while you're doing this, I would just ask if you don't think maybe it's a good idea to clarify that. The other thing that comes to mind, though, is that when you look at 2035.5, the language is different. So 2035.5A1 doesn't have the same language as 2035. Now, I know 2035.5 is referring to shelters, and 2035 is referring to regular vet hospitals, but it would seem to me that it should be consistent. And again, what happens here is that I'm dealing with situations, and again, I've represented shelter vets because they have premises permits and they get complaints written to the board. And again, a lot of these expert witnesses, we're not just dealing with the public and we're not just dealing with veterinarians, but we're dealing with the expert witnesses who don't really understand these regulations necessarily. So it would seem to me that we'd want to clarify that prior to. The other question I have is, when you're talking about in a shelter setting, in 2035.5, who is the supervising veterinarian? And I ask that for two reasons. Is it the premises permit holder, or is it the person who just happens to be there that day? And then when you're talking about a VACSP holder, that person has a specific supervising veterinarian. When they get the permit, they have to have the name of a supervising veterinarian. So, and sometimes that's the permit holder, and sometimes it's not the permit holder. So when we're talking about, and if you're going to call it supervising veterinarian in capital letters, who does that really mean? And it would just be nice to have clarification there as to who that person was. Thanks.
Ellen?
I think it depends on how many veterinarians there are associated with the organization and who happens to be there at that particular day. I hold all the premise permits for our 4 shelters. We have 2 staff veterinarians that rotate through 3 of the shelters. If there's nobody around, the default position is me.
Dick?
Yeah, I don't think we can be more specific than that. I would agree. Going back to item D, it's the dilemma we're in all of the time, because I think that in the first sentence, we're talking about small animal medicine. In the second sentence, we're talking about production veterinary medicine. So the criteria for a VCPR is different in each situation, and I think that's what we're trying to capture. At least that's how I read it. And that is, like I said, that is existing, and I don't know how we can make it more clear having those 2 different areas of veterinary medicine.
Hi, Erica Hughes, California Animal Welfare Association. I think to that point, if in 2035.5, instead of saying notwithstanding subsection C, if it says notwithstanding subsection D, then it really removes D from the from applying in the shelter context, and 2035.5 and the language in that would be what?
You lost me.
Oh, okay.
Well, first of all, we're not there yet.
Okay. I was just addressing the issue of how to reconcile what's in 2035 with what's in 2035.5.
Okay, why don't you just sit there? Don't move.
Okay.
Let's see if we can wrap up 2035, if there's any other public comment.
So as I understand it, the subdivision D, perhaps sentence 1 applies in the small animal context and sentence 2 applies in the production animal context. Is it?
That's how I read it. I might be misreading it, but.
And I think that's important, because when I read it, I have no idea that that's, in practice, it looks more like small animal, and I think there may be a need to clarify, but what I would like to do is research the genesis of 2035D to figure out, if possible. I know that our rulemaking packages only recently have been a lot more detailed. So if I can figure out why 2035 is worded the way it is, that might help us figure out if there's a better way to clarify the two sentences.
So if you go to 2032.1 in the definition of the VCPR, B2 kind of has both scenarios there, where either you do, you have the examination, let's see here, do I have that right? This means that the veterinarian is personally acquainted with the care of the animals by virtue of an examination of the animal or by medically appropriate and timely visits to the premises where the animals are kept. So to me, that's trying to capture the two different types of practice, individual care or herd health. And I think that's what we're trying to capture here too. I'm assuming, because I didn't write this.
I appreciate that, which is helpful, although I think it's got limited application because, that starts out with the veterinarian has sufficient knowledge of the animal, which means that they're personally acquainted because they've examined. The problem with potentially, I don't know right now, 2035D, as Bonnie's pointing out, is it before they've done anything or delegated tasks? Do they have to examine before? Or is it just at any time?
I think that varies whether it's an individual care or whether it's a herd health program.
Okay, so. Yeah, the problem is that because the two sentences are separate and distinct from each other, they contradict. They don't necessarily let us know that it's either prior or it's when it.
So we need to
when
address
it's
it.
necessary, yeah.
Okay.
I mean, maybe it's just a matter of combining the two sentences so that it's clear that it's an either or we clarify that it's prior examination before delegation in specific circumstances.
Okay. So then, well, my motion didn't get a second, so.
I'll second your motion.
Well, then okay, so the motion then would, is to send it as is, moving E to 2035.5, but if we're going to change D, we need to do that before, or clarify D, we need to do that before we send it to the board.
I actually have a suggestion for that, not related to the shelter setting.
Okay.
That if you eliminated the first line of D, and then you started the sentence with prior, and it reads, prior to the delegation of any animal health care tasks to an RVT permit holder or veterinary assistant, comma, the examination of the animal patient shall be conducted at such time as good veterinary practice requires, consistent with the particular delegated animal health care task.
And what does that say?
It says that it says that you need to
does that have
examine
teeth
it
in it?
first when good veterinary practice requires
Okay.
that.
To me, that still means that there's got to be an examination before delegation. Because it's starting off with prior to the delegation. The examination then occurs.
Except for it's qualified by at such time as good veterinary medical practice requires.
Right, but that's just the examination. When
So
is the delegation? When does that happen?
Well, it means that you could delegate prior to examination if that was consistent with good veterinary medical practice.
Okay, what I think we need to do is we need to look at this section, then I think we should put it on hold, because what we don't want to do is to corner our large animal practitioners.
So to that end, may I suggest in D, the second sentence, to include the examination of the animal patient may be conducted at such time under production or shelter medicine considerations that good veterinary medical practice requires consistent with the particular delegated animal health care task. Infuse that second sentence with the reference to production animal and animal shelters, maybe would help clarify it.
I think unless we clarify the first sentence, which would still apply to the herd and large animal setting, we can't just aim the second sentence at the limited practices, because the first sentence requires examination before delegation. So no vet could delegate until the vet had examined, regardless of the practice, regardless of when we're talking about good practice for the animal, the situation. The examination has to occur, even though there are written orders or procedures letting the RVT and other care providers know what to do. The examination per D, sentence 1, must occur before delegation. So I think what we're going to have to do is say,
I don't think we need to address shelter medicine here, because we're doing it in 2035.5. We're saying on 2035.5, we're giving literally the scenario of what happens in a shelter. But I am concerned about large animal practice in D. And I don't want us to get into a corner there, because that's not the reality in a herd health program. Unless I'm missing something, and there's more people here that understand that better than I. Because it is addressed in the VCPR. And I think we need some type of verbiage that does it, because I think that in a small animal practice, in an where we're caring for individual animals, I think that the animal needs to be examined prior to delegating tasks. But that's not practical or realistic in a herd health situation, which literally shelter medicine falls into also, or a large kennel situation will fall into. So we have to look at both scenarios. So I do like the first sentence when it comes to individual care. Maybe the second sentence, the examination of the animal patient in a herd health setting shall be conducted at such time as good veterinary medicine practice requires, consistent with the particular delegation of the animal health take care task.
could we split it up so that we've got subdivision D, and that begins with except for the provisions of subdivision E, the vet has to examine prior to delegation, and then the second sentence of D becomes a new E, so that it's its own provision, not reliant on the first sentence of D.
That's fine. I mean, that's, to me, is, that's your job, how to put it together.
Okay.
Just so you don't change the meaning.
Right. So I just want to say that, you know.
So the second sentence would be then E, and would read, the examination of the animal patient in a herd health setting shall be conducted at such time as good veterinary medical practice requires, consistent with particular delegated animal health care tasks.
Right, and then D, the first sentence, before the first sentence, it would just be inserted except for the provisions of, or some legal wording that gets us to where we need to go. We want to carve out situations under new subdivision E. So in D, it would say except for the provisions under subdivision E,
Okay.
the supervising veterinarian shall have examined. That way it's clear that subdivision E creates the examination and delegation procedure for herd health. Okay.
I agree.
I'd like to hear some comment from the audience. Stay there, stay there.
Grant Miller, CBMA. The antenna went up when I heard the word setting, because the last time we used the word setting in regs, it was range setting, which is in relation to musculoskeletal manipulation, and that has caused reverberation issues with clarity and ambiguity for many years. We don't have a definition of what a herd health setting is, and so I would be very concerned about making sure that that's defined if we're going to reference it in statute. Furthermore, if you look at the VCPR 2032.1, routine visits or medically appropriate visits to the premises where the animals are kept does not specify solely that it's a herd. We've always talked about that being in relation to dairy cattle or to sheep flock. But I have heard of circumstances where veterinarians go to a dog breeder's house where they have a kennel or a breeding, operation, and they apply that interpretation of the VCPR for smaller scale operations. There's nothing that says the number of animals that have to be involved. There could be 2 animals, and if you're making medically appropriate and timely visits to the premises where the animals are kept, then there's nothing in 2032.1 that says that that's not okay. So I think we need to really stop and take a closer look at this if we're going to head down the road of rephrasing this way. I think we need to be doing it in consideration of 2032.1 and also in consideration of adding definition if we're putting new terms. Thank you.
Then I guess I'd ask Dr. Miller, do you see the confusion in item D?
I definitely see the confusion in item D. This is not the first time that this issue has come up. And as Bonnie had mentioned, there have been past legal decisions in which medically appropriate examination of the animal came after the time that the recommendation was made. I don't have personal knowledge of those in terms of reviewing the cases, but I am aware that they exist. And I think that what it really comes down to is this interpretation of the VCPR that allows somebody who's making a medically appropriate timely visit to the premises where an animal is kept to be able to direct someone to do something. For instance, if I have a beef cattle ranch that has a pink eye problem, and I know they have a pink eye problem, I have a vaccine program going for it, I culturize every year, I see the cows on a routine basis, there's an opportunity for me to instruct my client on what to do. If she calls up and says, gosh, suddenly today I've got 5 new cases, and that's a hot little bed of pink eye for this herd. It's not normal for them to get that many cases at that time. Because I have a VCPR established in that circumstance, I can tell her, okay, well, let's go ahead and give them some LA200 and, make sure there's no foxtails in those eyes. Go ahead and do that. I'm directing her to treat those animals without examining those 5 animals. but I tell her, I'll be out on Saturday. I'll follow up. So there's a situation where within the allowable limits of 2032.1, which is our cornerstone, that's the absolute cornerstone of, in my opinion, the regulations that we have, I can say, sure, go ahead and do that, and then I'll be out there to kind of culturize or do whatever I need to do to follow up. So there we go. The difference in that scenario, as I see it, versus what we're talking about here is in that scenario, it's me, the client, and the patient, VCPR. What we're talking about in 2035 is a veterinarian instructing their employees or paraprofessional staff. That's a different party. And what I'm seeing that we're trying to do is we're trying to force fit the needs of these shelters into 2032.1, which was never designed, it was never written with that in mind. And so is it plausible? I leave that up to the legal counsel. Is it possible to construe an RVT or a paraprofessional staff working at a shelter as a client that can do something on an animal without the veterinarian be there? I don't know. I don't know if that's the answer, but I think that's where we're running into this messiness. Is 2035 contradictory? Yes, but even more so when you're trying to apply it in a situation where you're talking about directing staff, not a client to take care of their animal. You're talking about staff that you're overseeing. It's a different ballgame with the number of players. Can it work? Possibly, but we'll have to choose the language very carefully, which brings me all the way back around to worrying about the herd health setting. Thank you.
Well, if we're talking about strictly our employees, which we are, and we are carving out shelter medicine into 2035.5, then I guess I would ask, why do we need the second sentence?
You asking me?
I'm asking anybody that.
That's above my pay grade.
So I would just, before you speak, I just want to point out that E is the only shelter provision that would have been inserted under 2035, and we've already determined that E should be moved to 2035.5. So we're no longer trying to shove shelter into the employee task situation. We potentially need to discuss it as we're reviewing 2035.5, but because we have a new consideration on the lack of clarity of existing subdivision D, we're solely focused on that employer-employee task situation. I just wanted to clarify that.
Valerie Fenstermaker, CVMA. So I guess a couple concerns going back to 2035A, where it says the supervising veterinarian shall be responsible. Just those words alone are a big concern as we start changing language around, because it inevitably comes back to the supervising veterinarian. And so when we start changing terminology down in D without necessarily knowing the history of how this came to be, I get a little bit concerned. If you look in the Practice Act, there are 5 or 6 notes under this section of when this section was amended. So going back, Tara, to what you said in the beginning, maybe it would be best to go back and look at the history as to how this all came to be. Obviously, it's been discussed many times over. It goes back to, what is it, 1967 or something? I don't know what it's.
79.
79. So this is not easy language, and does seem contradictory to me. But apparently, it's been amended several times. So unless we're in a super big rush to change this, I think it would be worth looking at the history and see why it says what it says, and maybe there's a way to take that and reword it down the road. Thank you.
So I don't know what is proper. We have a motion and a second. Do we table it or withdraw it to do the background research?
You made the motion, right?
Right.
It's up to you.
Okay, if the second will withdraw, I will also withdraw the motion.
Yes.
Okay. So we will then leave this for further discussion and research.
But we're moving E to 2035.5?
Yes.
I think that's helpful, actually, because now we can make sure that moving E, it's clear under 2035.5.
Do we need to make that official with a motion?
Yes.
I don't think we
That was the
do
motion.
That
at
was the
this
second
time.
then.
I'm sorry.
Yeah, I don't think we need to make it clear that E is moving to 2035.5 because we're not actually recommending anything
Okay.
at this time.
Okay.
So we can actually move it without making a motion. We can put it in 2035.5.
I would just ask that, do you want council to research the history of 2035?
Yes.
Great.
I think we can do that as the advisory board. I don't know if we have to go back to the board to do it. I think it's okay here. And that was the easy one. Okay, we're moving to 2035.5. Oh, boy. Duties of a supervising veterinarian and animal health care tasks for RVT, veterinary assistants, and I would say, and permit holders in a shelter setting. VA, CSP, I guess it is. Okay, well, this is new ground. Jennifer and I went over this several times, and this is kind of what we came up with, and I think is the crux of shelter medicine. That along with a new section that we're adding, 2030.6. So I would open this up for discussion. We had discussed this at the last meeting. The part that's in blue is is definitely new, the new concept of how to get this into regulation. So this is the carve out for shelter medicine.
Do we want to 2A and make that pursuant to written protocols, established written protocols?
It says in the title, supervising veterinarian establishes written orders.
I'm sorry. Oh, okay, sorry.
I'm sorry, I'm missing that. Where?
No, it's I'm confused. You're okay.
I know, I'm confused too.
You didn't see when it said written orders for right after the two before that.
Okay.
Does anybody on the committee have any questions about what's written as it is right now for 2035.5?
And we do need to add C in the obvious place where the parentheses is empty.
You open with the adding VASP. What's the acronym again?
CSP.
Permit holder. That'll be global through,
Yes, it'd be also an A. And throughout, I guess, yes.
Any questions or comments from the public? 2035-5.
Erica Hughes, California Animal Welfare Association, and it's really exciting to see this in print. We've been working a really long time on this, and there have been so many meetings and discussions, and I think it looks great. The only thing I would add is I like the exemption in E that it's okay for the animal not to have been examined if it's part of continuing treatment of an existing medical condition that existed prior to the animal being adopted. To add to that also, if an animal has been treated by a veterinarian in the community and is then surrendered with medicine to the shelter, that the shelter staff be allowed to administer the medicine prior to examination of a veterinarian, because that animal's already been examined and is currently being treated by a veterinarian in the community.
I would qualify that. That's assuming that the animal is indeed being treated by a veterinarian and not just being treated by over-the-counter Walmart drugs.
So maybe to confine it to prescription medicine administered pursuant to, at the direction of a veterinarian.
Yeah, I like that.
Do we need to say that? I mean, if an animal's coming back, if an animal comes into our facility, private facility, to board, for example, that has its own medication.
Is that what we're talking about? I thought we were talking about an animal relinquished with medication.
Correct. Same idea.
Well, maybe not. I can imagine an animal being relinquished by, it doesn't matter who,
right?
And they have a bag of pills with, and he said, I can't take care of this animal anymore, but it needs pill number 1 on Tuesday, and the bottle is unlabeled, and who knows what it is.
Well, if it's unlabeled, I would have a problem in our clinic.
Well,
too.
even if it's labeled, grandma's homeopathic magic potion. I think we would either have to qualify it to prescription item. I think that's the simple part.
So did you have some wording?
I don't, but I'm happy to work on that.
I have a question. So this is returning it to the same shelter that
No.
they picked it up from, because that's the language.
This is an animal being surrendered by its owner for whatever reason. Generally, they don't want to deal with the problem anymore, and they come literally with a prescription bottle with pills in it.
So potentially during the adoption time frame, the animal was seen by a different veterinarian.
This has nothing to do with adoptions. This is your dog, you've had it for 6 years, it's got some kind of chronic skin problem, you can't deal with the stench anymore, so you bring it to the animal shelter and dump it on us, but you're well-thinking enough to provide the pills of antibiotic that were once prescribed for that animal.
Okay, so subdivision E says animals that have been adopted and returned to the shelter. So this is a specific situation where the animal was.
No.
We need a new section.
Okay.
I'm suggesting I'm saying that this exemption that you just said is a good one, and we should add to that. We should have another exemption that covers animals that are surrendered to the shelter, that are under that are being treated by a veterinarian and have medicine that the owner has been administering to the animal at the direction of the veterinarian, that also be exempted from the immediate examination requirement. So
We can do that, but a new section.
Would it be a good idea to require the staff to reach out to any known veterinarian who prescribed the prescription, just to confirm what the dosage is?
It'll be on there. It has to be on the bottle.
Okay.
If it's, then isn't there already a valid VSPC, there's already a valid client-patient relationship, does it need anything? If you have a valid prescription that goes with that animal, somebody has seen it, you're under direction to give it, does it need any exemption at all?
I think the concern is that once you've surrendered the animal, you no longer own it. Now it's in the shelter system, and so I think that.
But the veterinarian still has the relationship with that patient, and if the.
No, but the owner doesn't have the relationship with the patient anymore.
Can a
They have
veterinarian have a
relinquished it.
relationship with an animal?
I have a client-patient relationship. I have a relationship with both. I've prescribed a medication. If the owner surrenders it, the medication goes with the animal. It's still valid to give it. Do you need an exemption to give it?
I think we can do that. Item F would be an animal that has been relinquished to the shelter with a prescription. Well, this is poor wording. We need to change that, but the staff can continue the treatment with a prescription medication prior to a veterinarian examining the animal, something to that effect. That would clarify it. It should go the other way. The staff can continue a prescription medication to an animal that has been relinquished to the shelter prior to a veterinary examination.
Well, we're talking about administration of possibly controlled substances.
No.
So I just want to be aware that, this might actually.
I don't know if a shelter would take in controlled substance.
We would refuse it.
Yeah, and isn't there already a provision that you wouldn't be administering that if you didn't? I don't remember what the specifics were, but I think that would be an exception just on the face of it.
This is the new shelter section, so I just want to make sure that we're contemplating what medicine is being dropped off. It's not just, joint pain relief. It's potentially, bigger stuff for seizures or whatever.
So
I think that microphone is the only one.
So Ken Pulaski with CVMA, exactly seizures. So a dog's brought in and is relinquished with phenobarbital. Are you going to refuse to take in the phenobarbital? And that is a medication that needs to be given prior to, if a veterinarian's not there, that patient needs to continue receiving the phenobarbital. So Alan, are you saying that you would refuse to take in the phenobarbital if a dog was relinquished?
We would probably refuse to accept the dog. There's no obligation for any shelter in the state to accept an owner-surrendered animal. We would refuse it.
You would all shelters.
I can't speak.
That's the point you need to worry. I mean, there's a controlled substance that very likely could be relinquished with an animal and that patient needs to receive that. So that's a consideration.
Or along the same line, either Tara or Leah, one of you just mentioned a moment ago, joint pain. I can see the scenario where an older animal has a almost standing prescription for an NSAID. Doesn't get it all the time, but gets it periodically. And then in a new setting, the indication for its being given isn't necessarily clear, and it's given and harm is caused. GI ulcer happens, and that's not even a controlled drug. But it is a prescription drug, so that qualification probably isn't quite enough.
I don't know which one. Oh, that's one that's working. I think, Tara, you brought up, maybe the way to solve this is to have, and I know it's more staff time, which is difficult in a shelter, but when there's a prescription, to have some staff contact the veterinarian that's on the bottle and just confirm it. That would give you a layer of assurance, because there are pet owners that get prescriptions and give it willy-nilly to all their dogs, or give it to the dog that it wasn't really prescribed for. I mean, there are people that do that. So maybe there would be an extra comfort level on this issue if there was just contact made with the vet that's on the prescription. I mean, you don't take in that many relinquished animals, do you, Alan? I mean, you don't. I mean, how many relinquished animals are we talking about in the shelter?
Thank you for bringing that up. I was going to bring this up. Welcome to our world. This is, it doesn't happen that much anymore because from a policy standpoint, we have set strict requirements on animals that we will accept as owner surrendered. But the public does consider us a dumping ground for problems that they no longer want to deal with. And this is exactly what happens.
Right. But would it be too much for the staff to do those?
Yes, and it's not professional staff either, or veterinary assistants. It's the front counter people who have an office full of people wanting to do various businesses with the animal shelter. They do not have the time to track down the veterinary practice that prescribed the stuff initially and talk to somebody there. They don't. At least in a high-volume shelter that we have.
Why can't we just stay, staff may continue to treat a patient with a prescription when it is relinquished by an owner. The staff must comply with state and federal regulations or laws or whatever. I mean, if the phenobarb comes in, if there's a veterinary assistant controlled substance permit holder, they can give the medication, but a lay person couldn't, or a veterinary assistant couldn't. They have to comply with laws and regulations. I think it's, at least until the veterinarian gets there and examines the animal, the example of phenobarb is a great example. That animal needs continued treatment until it can be examined.
Do we need any kind of log for this situation? Because I don't think existing law provides for when the client comes in, and it's not a client at this point, but today we're talking about a client returning with controlled substances and giving it to the veterinarian or staff. In this situation, we're about to provide for owners relinquishing an animal with a controlled substance to a VA who nobody has any idea who they are or what their background is, and they take the medication and it's not administered to the animal. I'm just saying, do we need to, if we're providing for this, perhaps we also need to just consider that medication needs to be documented somewhere.
Well, it happens at our practice all the time. Owners come in with an animal on phenobarb when we're boarding them. So that drug is, just like it goes out, it comes back in, and the administration of that is done by a veterinarian or RVT. I bumped it.
But are you the treating veterinarian?
Not necessarily. It may be coming from another clinic and boarding at our place. So that drug gets put in the box, and only in our case, it's a RVT or veterinarian that gives that medication. So why couldn't that same scenario fit with a shelter?
Well, there's still a continued duty of care because the client is paying for those boarding services, and they're going to come pick that animal back up. And if anything is wrong with the animal because they didn't get their medication.
But there's an ethical situation with the animal coming to the shelter. That animal has to be taken care of, unless you have a policy of not accepting it. But a shelter that does accept them, we have to have a scenario for that animal to be treated just as if that animal is at the shelter and is diagnosed as a seizure, and the veterinarian puts him on phenobarb. I mean, that's a fairly common scenario of a controlled substance. I think controlled substance for osteoarthritis, I think, is less common. We have a lot of animals on phenobarb. So I think we need to provide that scenario for a shelter setting for those that do it. And I think we just need to wordsmith it in. I think it's a great scenario that we have to address.
Again,
Ignoring the animal, I think, is not ethical.
Again, I wonder if it's a valid prescription. Again, if it's a valid prescription, why do you need to carve out an exemption? I mean, their staff could call me and I could say, take time out of a busy day to say, yeah, I prescribed it. give it like I said. But just the fact that the animal's gone from one owner to now you're not considered an owner, but a caretaker of that animal, why is a valid prescription all of a sudden not valid and needs an exemption to be given to it? I don't understand.
Well, the scenario that we're trying to make clear is that when does that animal get treated prior to a veterinarian's examination or not? So we're trying to address that because we're setting up scenarios that staff can do certain tasks. So I think because of the phenobarb, I think it does have to be clarified because a veterinary assistant cannot be treating that animal in a shelter situation or any other situation.
I think the reason for putting it in there, calling it out specifically as an exemption, is just to remove the ambiguity, because I think if that were even without the exemption, you could make a good argument that you're allowed to do it, the shelter staff is allowed to do it because it's pursuant to the prescription. But then the other argument is, well, no, there's this examination requirement in a shelter, so, does that trump? And so I think laying it out and providing a specific carve-out then removes the ambiguity, and then you don't have to worry about having to make that argument.
So, could we split up E into two paragraphs so that it's E, animals that have been,
Yeah, I'm suggesting that this verbiage be F.
totally new, okay. And then E from 2035 would be new G under 2035.5. So I just want to make sure we get some intent language down, and we can wordsmith it as it's on its way to the board, but I just want to make sure that the recommendation is clear. So new subdivision F would be animals surrendered to a shelter with prescription medication, maybe
Treatment may continue.
Prior to the examination by a veterinarian.
staff, specifically RVT, VACSP holder, or VA, may continue administration of the prescription medication prior to veterinarian examination.
And can we insert valid prescription in there? Erica is correct. You'll get a bag full of stuff from various dogs, sometimes from multiple practices, and you would question yourself, even if the dog presented is among those that are listed on the medications.
Do we need to cross-reference the duties that a VA can do? Because a VA, without having a VA-CSP, cannot administer controlled substances.
I was thinking that also, but then, isn't that already stated?
No, it's not.
Not stated here, but
Elsewhere.
across the board.
But we're creating new exemptions for staff in a shelter setting.
Doesn't matter. Doesn't matter. We're not exempting, at least my understanding is we're not exempting a veterinary assistant or a veterinary assistant from dispensing controlled substances. They still have to have a VASP, ICKMOESE.
Okay, so I ask these questions so that you guys deliberate the situation, and then we get to add it to our rulemaking file, so OAL and the public and attorneys know that the intent of the language itself. If it's not clear, we can go back to the rulemaking file to flesh out what you intended. So Your advice is no cross-reference, we don't need it,
I-
with respect to VA duties.
Right.
Okay.
Are there over-the-counter medications that a doctor, is that considered a prescription if a doctor tells? So are there over-the-counter medications that, that if the animal, that a veterinarian has suggested or advised a client to give an animal, that if not given for a period of time upon surrender would be detrimental to the animal? I mean, I understand phenobarbital, but are there other?
I wouldn't say if not given, well, there may be, but what comes more to mind is something not prescribed, not evaluated by a veterinarian, and is just purchased, stolen or whatever, and given, and that causes harm. You continue to give paramite dip, or you can, well, that's a prescription item, that's a bad example, but I can think of over-the-counter products that, were they given incorrectly, canine flea medication to a cat would cause harm.
I think she's asking the other way around. Is there an over-the-counter product that if you stop giving it, would it harden the animal? And I would say no.
Or even, I was thinking a procedure, like dressing changes or something that an owner would do at the advice of a veterinarian, but isn't necessarily, isn't a prescription with a bottle and instructions on it.
I would hope staff would be advising the veterinarian that this is what's going on. I don't know if we can include every scenario.
Wouldn't that fall under A to C, or rather, the vet establishing written orders for medical conditions? I mean, if it's dressings, that's an obvious condition. That's something that will need to continue treatment. But if it's internal and we're not, the receiving staff has no idea what the underlying condition is from their visual assessment, I think that's really what we're trying to get at, right? Otherwise, it's obvious. It's a condition that we've already provided for under the subdivision A.
Protocols. Any other discussion from the public? So I guess the question is, we have two choices. One is to move it to the board with staff taking our intent and wording it, putting it in writing, and having the board then be the final one addressing it. Or the other choice is for staff to put it together and bring it back to us at the next meeting. I would say that's the comfort level of this committee.
Any objections to seeing it again in November?
No.
I don't think we need a motion to do that.
Okay. Okay, then the item 2030.6 and 2030.7. So I want to start by saying that out of our ignorance, we included 2030.7. It may not be necessary, but I'll explain where it all came from. So what we decided as far as the minimum standards of animal shelter is let's take the proposed, you've already approved of, and it's going to the board, which is 2030.1 small animal fixed facilities, which is a couple of pages beyond the blue section. We took a look at every one of those items and said, does this fit a shelter fixed animal practice? And there were a couple of sections that I did not think fit, and Jennifer said, oh, yes, they do, so I got vetoed on that. But we went line item through line item and made very few changes in it, so I think that that's what we need to do. The parentheses, the number in parentheses is like we did with the other system. For those of you that are new, that refers back to existing 2030, which is small animal fixed. And so we actually put that in there to make sure we cross-referenced it so we didn't miss anything. And it was all, because we moved things around a little bit to make sure we didn't miss anything. And if there's a question, you know where we got it from. So I don't know what the most efficient way of going through this is. We could go item by item or page by page. What's your comfort level? We've taken it right from the new 2030.1.
When you say page by page, do you mean 2030.6 and then 2030.7?
No, I mean the first page of 2030.6, item A through N2.
Okay. I'd like to propose we just start with your preamble there.
Oh, yes, good idea.
And discuss that first. For the purpose of these regulations, animal shelter facility shall mean a building where veterinary medicine and its various branches are being practiced and where veterinary services are being provided to stray, unwanted, or seized animals that are deposited or impounded by a privately or publicly operated agency or organization. We start there with any comments from the committee?
Sounds fine.
Sound reasonable?
Yeah.
Public?
Okay, I see a real problem with this, and the reason being that we've got rescue organizations out there, and I think we need to clarify that these rescue organizations don't fall under this. I mean, I think that, you know, we all agree that maybe the rescue organizations, there need to be laws regarding rescue organizations, but I think we need to make sure that this does not apply to them. Because the way it's written, it's really broad. And I understand that you want it to be broad, but the first problem I have is that you don't have relinquished animals in there. So I think that's the first thing, is that it should be added. What we just spent a lot of time talking about are those owner relinquished animals.
You wouldn't say unwanted is relinquished?
No.
No, I don't, and my other question is, what is unwanted? I don't really know what unwanted means. I understand seized, but then when it says that are deposited or impounded. So deposited, how, to, at? I mean, I don't really understand what deposited means. And the reason I'm looking at this really carefully is because I really think we need to make sure that it doesn't somehow morph into being used by rescue organizations. Because right now, it's not clear. The way the regulation reads now is it specifically talks about animals impounded by a government agency. So it's really clear. And I know we don't want to just stay with impounded, but I think we need to add relinquished. I think we need to define deposited and figure out what we want to say, and then maybe tighten it up as far as who these privately and publicly operated agencies are. Because I think we're talking about public government animal control agencies. Why don't we just say that? And if we're talking about private agencies, why don't we go back to the wording in the other regulations that say that there are private agencies that contract with public agencies to perform the duties, so that we kind of clarify? I mean, I don't know. What do you think, Alan? Do you think I'm being too fussy, or, I mean, I think that this really concerns me, this definition.
I can understand that, and I don't disagree with you. The rescue organizations and some humane organizations do need more oversight. But if the first bite of the apple is going to be the municipal animal control jurisdictions and those agencies or those nonprofits that contract for or to provide those services, I think that's a good start.
Then I would recommend that maybe you consider defining it a little tighter that way.
Dick?
Well, Dave Johnson brought this up at the last meeting, and to me, it's a huge loophole that does need to be addressed. And the reason we wrote it this way is to address it. And that is, if there is an organization that is doing veterinary medicine, why wouldn't it fall underneath our jurisdiction? The example that Dave gave and Jennifer said goes on all the time are groups that come in and cherry pick the adoptable animals out of the shelter, take them and do whatever. If they're themselves having surgery done, if they have the facility to spay and neuter them, why wouldn't that fall under our purview? It sounds like, and I'm not in that area of practice, so I don't know, but it sounds like a huge loophole to me that needs to be addressed, and why not address it now?
Is it because the rescues own the animal?
No.
And then therefore are using volunteers to provide services, medical services, veterinarian services to the animals?
I think that is a concern, and that argument has certainly been made that that rescue groups can avail themselves of the owner exemption to the Practice Act and therefore can practice veterinary medicine on an animal so long as they don't run afoul of animal cruelty laws. I think this is a really good definition of animal shelter facility because, as Dr. Sullivan says, it brings rescue groups into the purview of the Veterinary Medical Board as long as they're practicing veterinary medicine. And the alternative, if you leave them out, is that they will continue to operate under the theory that they are owners and can provide veterinary medicine up to a certain point, and unless it constitutes animal abuse.
I agree.
I guess what I was getting at is I think that those rescue groups fall under the Practice Act if they're practicing medicine, period. So my thought was that the reason for this is to carve out the animal shelters and allow the animal shelters to be a separate entity. Whereas rescue groups are the owners once they get those animals. If they're practicing veterinary medicine, they should fall under the Veterinary Practice Act, period. I mean, I don't think that they should fall into this special carve-out where we're trying to look at the unique situation in the government shelters and in the humane societies, the contracted government shelters. I mean, to me, that was a carve-out to address a specific need, whereas rescue groups should fall under the Practice Act, period. I mean, just all the other regulations.
I think what we've seen is larger rescue groups that have a large number of animals end up hiring a veterinarian to practice veterinary medicine on the animals and then fall under the exemption. Or attempt to use that to escape enforcement of the Practice Act over the animals rescued.
I know, but that should be just enforced under the regular Practice Act and not allow them to fall under this. I mean, that would seem to me that you can go after, if a veterinarian is going out to a rescue group and is not complying with the Practice Act, then we should be able to go after him under the other provisions of the Practice Act and not have to necessarily push the rescues into these special terms that are carved out for shelters. Because you can still go after the veterinarians, you can still go after an owned animal exception if you think it's inappropriate under the circumstances.
I guess I don't see the downside of that. I guess I don't see the downside of putting them in, having them in this section because so it's clear that they're under this and they're not getting through a loophole.
Well, it just depends on what you end up with in this section. That's my concern, because if you are going to pare down, and if at some point in time, the provisions from 2030 get pared down to fit the unique situation in a shelter. For example, there's no client, so all throughout here it talks about a client. There isn't a client. So some of these things, might get pared down, and then you would be opening up to allow the rescues to take advantage of this now sort of pared down regulation, where they should really be complying with the whole other regulations.
Well, there are clients, I was told there are clients, though, and that's why it was left in. That clients do come in and adopt animals, and they come back, if they get them spayed and neutered, they come back, they need the signage there, they need the information there. So I would guess, I had the impression, working with Jennifer, that clients should be left in this section.
There's a couple things here that, again, I think is a situation where this is confusing to everybody here. Can't imagine what the person watching this on the internet thinks. So the animals that come into the animal shelters through animal control, we are repositories for these animals. We don't own them. What has always bugged me is the attitude by the rescue groups that when they pull an animal from us, all of a sudden they are the owner. So I think there needs to be some legal clarification of what exactly the status of these rescue groups are relative to ownership of the animals. If they pull an animal from us, the responsibilities to spay and neuter are conveyed to them. There's then their responsibility before an ultimate adopter acquires the animal, that animal will be spayed or neutered. They're not exempt from that. So I don't see how they can be exempt from anything else that we as municipal animal control jurisdictions have to do. But that has never been legally qualified. I didn't want to bring it up right then, but we already have the reference to owners. If an owner surrenders an animal to us, they essentially give up their rights, but we still don't own the animal, and apparently neither do they, because we again are a repository for these animals. So I would question, contrary to what Jennifer may have said, and she no longer works for us, so I can say that, why owners would be referenced in this particular section.
Ken?
Yes. So I wholeheartly agree with Dr. Sullivan that this would be great if we can get the rescue organizations, we do know how they can be there can be oversight with them. Is your intent, though, with this, that they would fall under the same exemptions then that were just carved out under 2035.5 for shelters? Because that's the way they would be considered a shelter, and they would have the same exemptions that they could provide those services upon written order without being seen by a veterinarian?
Yes.
That is your intent with
Yes.
that?
So just for clarification and to further confuse things, so there are rescue organizations that physically do not have the animals at their location. They foster them out to various and sundry people. They may have 20 animals. They're a rescue with 20 animals, but they're never in one spot. And so that further complicates how we would try to enforce anything.
I think it's good to try and determine some type of oversight over the rescues. Personally, I would not be comfortable giving them the same carve-outs and exemptions that we're giving to municipal shelters.
Okay, but they do have a veterinary oversight, a veterinarian with a license. These tasks are not.
And that's fine, so they can provide veterinary care under the rest of the Practice Act, but not, so we in 2035.5, this is carving out specific that they can perform with written order vaccinations and prophylactic control of internal parasites and external parasites on intake. So now we're saying that rescues can do that as well because they have a veterinarian that provides that. And in Alan's scenario, somebody goes and picks up a kitten at the shelter and takes it to their home as part of the rescue, and they're vaccinating and providing parasite control under the written orders of the veterinarian of that overall rescue that's overseeing 20 households that are going and picking up kittens from the shelter. That's where I have a concern.
I have a question, maybe for Alan and Tara. Alan, to clarify, your statement about the owner who relinquishes an animal, who no longer owns it, to the shelter who takes it in, who doesn't own it?
Correct.
Who owns it?
Nobody. Maybe the state owns them. I don't know. It's not clarified anywhere.
Well,
Valerie Fenstermaker, CVMA. So this may be another job for legal counsel to look into. So a number of years ago, there was an issue with a rescue and section, and actually there was legislation passed that was 4809.5 regarding inspections that said that and this had to do with the rescue group, that they did not have a premises permit, therefore the board could not go in and inspect them unless there was unlicensed activity. So at that time, there was a lot of discussion about whether or not rescue groups were under the authority of the board. So just so you know, I would look at 4809.5 as part of this discussion because it was a pretty big deal at the time and seemed to remove, unless the rescue group was actually practicing veterinary medicine on site and it was deemed that there was some type of unlicensed activity going on, you might want to go back on the history of that code and that section and look at it, because I think it may impact what you're trying to figure out right now.
Lunchtime.
I will stand by the premise, if there is the practice of veterinary medicine, however it's done, wherever it's done, it should come under our purview. And right now, there's a huge loophole. Dave Johnson spelled it out very specifically at our last meeting. And if we're going to encompass that, I think this is the avenue to do it. But it's this board's decision, and I'm glad Alan is here today because we need the expertise of shelter medicine people in writing, and to me this is the most important section is that preface. But if the facility is large enough to be doing surgery or taking in animals that are relinquished but not impounded, and are providing veterinary services for those animals, I think they should come under our purview.
And again, just to muddy the waters here, so in the biz, there is currently great emphasis on not impounding animals. And there are various rescue groups and various organizations who believe that there should be an initiative to capture the people before they even come to the shelter doors and divert those animals to rescue groups or other groups so that we as the municipality never even account for those animals. That diversion, in the dog sense, not in the drug sense, can be and is significant. And if we look at the whole issue from protecting the public and protecting animals, these animals then who knows what happens to them? We don't get to see them, we don't get to evaluate them. The rescue groups then have them, and there is no oversight. And some of these rescue groups are one individual with a dozen kennels in their backyard, and they may have 30 animals there. I know they're over their head. Everybody's shaking their heads, yes, because this is an everyday occurrence for us. And if we go down through the list of things that their facility should have, they don't have proper drainage, and I harp on this all the time. Cross-kennel drainage is terrible. And there are, I know I'm rambling. Let me get to one other point, please. So I have been inspected a number of times, and it's been made clear to me, and I'll sit corrected if that's not the case. So if I have a premise permit and it's for the surgery, and I have it for the whole shelter, I don't care where anybody goes, they can go anywhere they want. But strictly speaking, the premise permit is for the spay-neuter surgery. And if the door to the kennels is over there and the door to the spay-neuter facility is over here, the inspector cannot go and inspect the shelter itself. That's where all these problems associated with communicable diseases amongst the dogs with cross-kennel drainage occurs. These are not facilities that you and I would ever even want to keep an animal. Who is protecting those owners and those animals when they wind up in those situations? That's what I think the crux of this should include.
Ken?
Just a quick follow-up comment. So I wholeheartedly agree that anywhere that veterinary medicine is being practiced, they ought to fall under. And if we can capture them with this, great. So I would suggest maybe considering in 2035.5, if you just added in some of the language from the previous preamble, that in this section, it refers only to a shelter setting where in a city and county animal care and control agency or an organization that contracts with. So if you make that specifically for a municipal type shelter, then those exemptions fall out, are for those shelters versus any type of shelter, including a rescue, would fall under the 2030.6.
So I would say I appreciate that concern. I think where we struggle is in distinguishing between private SPCA's and humane societies that exist throughout the state that have been, many of them incorporated for over 100 years, and function as responsible shelters that really serve meet the needs of the community and help pick up the overflow and the slack for the public animal control agencies in the area. Distinguishing between those and these rescue groups where it might be, one or two animals in somebody's house or, 20 animals among 20 different homes. So I do appreciate that concern. So I don't know if maybe we would want to look at trying to parse out these, what we consider to be these mainstays, these cornerstones of our communities, the SPCA's and humane societies, and separate those out from the rescue groups that really aren't in the public eye. They're not, these animals are hidden. So maybe if it's a shelter operating in a public building, or maybe if it's some sort of qualification that would still enable the shelter to avail itself of the privileges of 2035.5, even if they don't have a contract. So I'm thinking of something like, for example, like East Bay SPCA, it's not an issue, East Bay SPCA. So they're a, big established SPCA in Oakland. I don't see any reason why and it's a public facility in the sense that the public goes in there. It's a known entity. They have a business license. They have to comply with laws. I would not put them in the same category as a private rescue in someone's home. I'd have to think about how to distinguish them from each other, but they're
And
not
they-
the same.
They don't have a contract with the city or the county or anybody?
East Bay SPCA does not, and there are many that don't.
Yeah, correct.
For example, Woods Humane, another one, well-established facility, Humane Society right next to San Luis Obispo Animal Control. They do help, and they should be able to avail themselves of these privileges, and shouldn't be put in the same category as a rescue group that's off behind closed doors doing whatever they're doing. Not necessarily bad, but not known.
So it doesn't sound like then, particularly with that example, East Bay SPCA, that 2030.6 A through Z really is even a big factor for them. They're probably doing all or most of this anyway. This is written, correct me if I'm wrong, to hopefully cover those entities that aren't doing that level of care. And the term, bantered around is this amorphous rescue. And it just seems like a huge concern that we haven't been able to wrap our regulations around to get rescues to follow the same rules that people with licensees have to follow, people who have permits have to follow.
So I would say that rescues should have to comply with whatever you end up deciding for 2030.6, which, however that ends up looking, but shouldn't be able to qualify under 2035.5, as Dr. Pulaski said.
Well, that's going to be some gymnastics then, so we can't have it both ways. They're either in, or we're back to describing the traditional shelter, and they're out there unregulated. Now, if they're not practicing veterinary medicine, if they have animals come in and they have a veterinarian doing the treatments and everything, then it doesn't fall under this. But if they're doing it themselves in-house, then we've got to capture them in some fashion. So what I'm hearing the consensus or the recommendation is that we reword the preamble to 2030.6, since that's going to come before 2035.5. We rewrite that to address the shelter setting and not address the rescues.
Okay, let's sit on that and break for lunch and reconvene at 1:30.